Let's come out here, Christopher.
No.
It's okay. It's okay.
No.
Okay.
Here.
So,
No.
listen.
No.
Listen. Okay.
We've seen that moment before. Christopher Scholtes realizing what can't be undone. The Arizona father accused of leaving his 2-year-old daughter Parker in a hot car on a 109-degree day, leading to her tragic death. This is a story that has unfortunately become all too familiar. But what investigators say Scholtes was doing while Parker was trapped inside, that is what makes this case so hard to comprehend. And now a judge has ruled whether the jury will ever hear that. And we're going to break it down with an Arizona attorney. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Hey everybody, real quick, this is another Law&Crime legal alert. There are allegations right now claiming that online apps like DraftKings, ESPN Bet, BetMGM, Bet365, Fanatics Sportsbook, Caesars Sportsbook, that they are engineered for addiction. These multi-billion-dollar companies allegedly continue to put profit over safety. Every small payout, free bet, boosted parlay, that can trigger a dopamine rush that creates dependency and a destructive habit. They can keep users hooked and trap people in a cycle that can lead to serious financial loss. Well, I'll tell you what, our legal sponsors, they are taking on the online gambling industry to seek justice and potential compensation. So if you or a loved one has struggled with addiction or financial hardship or mental health issues due to sports betting apps, then visit gamblinglawsuits.com/sidebar to take a short quiz and check your eligibility to file a claim. This story just screams one word: preventable. Preventable. A mistake, if that's what it was, if that's what we're dealing with, no parent would ever want to make this mistake. You have a father in Arizona facing first-degree murder and child abuse charges after his 2-year-old daughter died in a hot car. You've heard about these cases before, but I will tell you this one, the allegations, Christopher Scholtes, he's accused of playing video games after leaving his daughter in a hot car and then forgetting that she was there. The temperature that day inside the car, reportedly 109 degrees. I haven't even mentioned what else investigators say he may have been doing at that time. We will get to that. But the body cam footage shows the moment that police arrived, and you can hear the fear, the confusion in this guy's voice as he realizes what has happened.
Anything. Anything.
She's dead. Like, I need to be with her.
Oh my God, my no! No!
Now, to be clear, it's not as if investigators and authorities and prosecutors are saying he intended for this to happen, but clearly they are saying he's criminally responsible. And here's the twist. This apparently isn't the first time investigators say Scholtes left a child unattended in a car. And we're going to get to that too. But right now, as Scholtes' case moves towards trial, a recent judge's ruling has shaped what jurors can and cannot hear about that day. And that is really, really important. That's what we're going to talk about, because just wait until we get to what investigators believe Scholtes was allegedly doing while his child was trapped in that hot car, and whether the jury will ever hear about it. We'll talk about it. But first, let me lay out exactly what this case is about from start to finish so you can really understand what we're dealing with. On July 9th, 2024, Christopher Scholtes, a father of 3 out in Arizona, returned home from running errands with his 2-year-old daughter Parker strapped into her car seat in the back of the family car. Now, Scholtes initially told police that he left Parker in the car, that she was sleeping, didn't want to wake her, and you can hear that for yourself.
We went to go we just came home. My daughters were at Elevate with my friend next door. They got home about 2:45 or so, and then we've just been hanging out at home. She was sleeping in the car, and I had the car on. But it has a sensor where every 30 minutes or so it'll turn off if you haven't moved. I swore she was in the house playing with her sisters like she always does. Just been right now, haven't been doing anything else really on the house. And like
What time?
But we never do this anywhere, but I'm home, right? Like you're home, you're safe, your kids are home.
Now, the car was apparently running with the air conditioning on, but Scholtes assumed that it would automatically shut off after about 30 minutes like it had before. The problem was he allegedly never went back to get Parker, and police say she remained inside of that car, 109 degrees, right, over 3 hours. That was until, according to the complaint, that Scholtes' wife, Erica, came home from work at around 4 p.m. She asked where Parker was, and that is when this husband, this father, apparently realized that he had left his daughter in the car. So he runs to the vehicle and finds her lifeless body still strapped into the car seat, blistering 109 degrees, the car parked in direct sunlight, the driver's side window facing west. Nearby security footage backed this up, showing Scholtes' car arriving at 12:53 p.m., just after his other 2 children got home. He's seen walking to the front door alone, apparently, no sign that he checked on Parker during the next 3 hours. That's based on the reporting. And his wife's car apparently arrives at 4:08 p.m., and then the 911 call follows 8 minutes later. By the way, here's a snippet from that call.
Thank you. And what are you reporting?
She was in the car sleeping. She's unresponsive.
Okay. And who is she?
Please.
Who
My
is she?
daughter. My daughter. Please.
And this was out in the driveway?
Yes.
Is she still breathing?
No, she's not breathing right now.
Okay, we need to start CPR right now.
Yes, we are. We're starting CPR, yes. Oh, my God.
Okay, is she breathing yet?
How long has it been? Half hour. It was, but it turns off. I've been checking. Oh, my God.
Okay, is she breathing yet?
Is she breathing? No.
So Scholtes told police that he left Parker in the car while he put away groceries, thinking that she would remain asleep. But the text messages, and this is key, the text messages between him and his wife, this led investigators to believe that this maybe wasn't a one-time oversight, okay? Because according to the complaint, text messages between Scholtes and his wife as Parker was being rushed to the hospital, they show a lot. They apparently read, quote, his wife saying, Erica, I told you to stop leaving them in the car. How many times have I told you? With Scholtes apparently responding, babe, I'm sorry. His wife saying, we've lost her. She was perfect. Scholtes replying, babe, our family, how could I do this? I killed our baby. This can't be real. Now I got to talk about this. Forensic interviews with his other kids, they have provided even more insight into past allegations, and we will get to that and whether or not it will play a role in this case. But the body cam footage from the scene, this shows the absolute devastation in real time.
Just to let you know, I don't want to feel like we're intruding, but we're gonna have to stand by with you for a while. All right.
Is there a reason why?
So any death, we have to treat like a crime scene. I know this is extremely difficult for you. This is a normal process that we have to follow through with. I don't want you to be blindsided by anything, but that's what's going to be going on for right now, okay?
So I'm being treated like a murderer?
No.
I just lost my baby.
Not at all. I know that. And I know this isn't easy for you. That's why I'm trying to be straightforward and honest with you, okay? I don't want to keep any secrets. I don't want to hide anything for you. Someone's going to talk to you about what happened, though. All right? We will keep you updated with everything.
My whole family, my whole family's gonna be ruined.
We'll be all right.
Shower.
So we can't let you do that right now. We have to stand by with you. Okay? As soon as you can, we will let you
You
know.
can stay in the room if you want, but I'm gonna talk.
I know this isn't easy for you, but the quicker we get this done and finished up, the sooner you can be with your wife. All right?
I'm trying
We need
to
stand
rinse
by
off
with you.
so I can go to the
I know,
hospital
but
to be with my wife.
we're not going to shower or anything right now. You need to stand by with us.
I don't understand why.
Okay?
And let me just say, aside from criminal charges, this is a family that's destroyed, okay? The grief is there. It's palpable. It's understandable. This is a tragedy. They'll never be the same. But you talk about the medical response. No matter what they tried to do, they couldn't save Parker. Now, she was transported to Banner University Medical Center. She was pronounced dead. Scholtes, reportedly, by the way, refused to plead guilty to second-degree murder. And now he faces first-degree murder. So he reportedly turned down that deal. I want to talk about that, too. And here's the issue. Aside from the fact of the video games, right? Court filings allege that Scholtes was distracted playing video games. And, by the way, investigators say he was doing something else, which we will talk about. But they also claim he was drinking beer. And this is all while Parker suffered from that heat exposure. Now, Scholtes' case is finally approaching trial, so I want to get into the latest in this story, the legal issues, and by the way, this decision from the judge on what the jury can and cannot hear. And I think it's really, really significant. So I want to bring on a criminal defense attorney and former federal and state prosecutor, Kurt Altman. Kurt, thanks so much for coming back here on Sidebar. Appreciate it.
Hey, Jesse, thanks for having me. My pleasure.
Now, this is a heartbreaking case. It is a disturbing case. It is a situation, unfortunately, putting aside guilt here or not guilty, it shouldn't have happened. We cover a lot of these cases, unfortunately. From a legal standpoint, let's start here. When you see this distinction between first-degree murder and second-degree murder or manslaughter in Arizona, particularly when you're dealing with a hot car death, what should we be thinking about?
Well, I mean, really, it comes down to what the prosecution has to prove and the ultimate penalty. This is first-degree murder because it's a felony murder charge, meaning they're alleging that child abuse was committed. And during that child abuse, by leaving the child in the car, the child died. That makes it, under Arizona law, first-degree murder. And that's what the prosecution is alleging, as opposed to second-degree murder, which they would have to show some sort of intent. And in this case, it would be some sort of reckless indifference under the law. That's the standard under the law to show that. But here, if they prove child abuse, it's first-degree murder.
But it's not necessarily saying he wanted his daughter dead. It's that he was incredibly careless and reckless and disregarded the clear inherent danger of leaving a child in the car. Essentially, not only is it his fault, but he's criminally responsible. But it's not saying that he planned this and premeditated on this and wanted his daughter dead, right?
That's exactly right. It's not the first-degree murder that we see in movies where someone plans a murder, goes out, hires a hitman, or sits up, behind the bushes and waits for someone. This is a death that resulted during a very, very reckless and careless conduct taking care of that child. Because the child died from that reckless and careless conduct, that makes it first-degree murder. So it's different in that way.
Right.
But the penalty is a first-degree murder penalty.
Life in prison. Right. Okay, so here's where things stand, and I want to get your perspective on this. And this new development, some would say, pretty shocking. So according to newly released court filings that were reviewed by People magazine, prosecutors say that Scholtes wasn't just distracted by video games the day that Parker died. They say he also searched for pornography on his PlayStation while his daughter was locked in that 109-degree heated car. But guess what? Jurors, they're not going to hear that. No, a Pima County judge ruled on October 14th that prosecutors can't tell the jury about those alleged porn searches. Judge Kimberly Ortiz said the state is, quote, precluded from eliciting testimony in its case in chief regarding the defendant looking for pornography on the PlayStation before his daughter's body is discovered, and that no witnesses can mention an alleged 2-minute search for pornography on the PlayStation that happened on July 9th, 2024. Kurt, why? Why is this not being allowed?
Well, it's so prejudicial. That's the layman's terms, right? It's going to be, if that evidence came out, it would be so bad for the defendant that the court's saying the jury won't pay attention to anything else. They'll convict him just because of that. It's unduly prejudicial compared to its probative value under the legal words, right? That means, hey, it's relevant, but it's so minimally relevant compared to how bad it's going to look for the defendant that the jury wouldn't do their job and evaluate the evidence correctly. So it's not going to come in. That doesn't mean that other evidence about what he did's not going to come in. That doesn't mean that he that he was playing on his PlayStation and doing things like that to ignore the child. That's all going to come in. They just can't say that during those 2 minutes he was looking for pornography. What's important is the court's ruling said in their case in chief. So that means the prosecution can't present it in their case. But if the defendant or the defense during their case were to open the door, as we say in the law, somehow allow or allude to something he was doing at that time, or somehow say that he wasn't doing certain things, they may open the door and the prosecution may be able to use that evidence when they rebut his case. But as it stands now, the jury's not going to hear that.
I get it. I totally get it. But at the same time, isn't it relevant to determine what he was doing? What was allegedly more important to him than checking on his child? You know, it'd be one thing. It feels in a way like the prosecutor's hands are tied, right? I mean, how can they explain what he was doing? Because then a jury could say, well, maybe he was distracted with something else. Maybe he was distracted with something more important. Maybe, you know, I guess, is it just let's focus on the video games and video games different than pornography? I don't know.
Yeah, I mean, I'm sure the court evaluated the fact that the prosecution is going to be able to get into evidence of his playing video games and being on his PlayStation and things like that. And the court probably tried to balance that and went, man, that's going to be enough. That's going to be enough for the jury. They don't have to get into this pornography because it was just a 2-minute search. And if they do, the jury's just going to tune everything else out because it's so prejudicial. Now, if I'm the prosecutor, and I've been in these situations way back in the day, where I'm like, Judge, every piece of evidence I present against a defendant is intended to be prejudicial. That's why I present the evidence. It's going to look bad for the defendant. That's why I want to get it in. But the judge, under the rules of evidence, balanced that out and said, you have enough other evidence. This is so bad, not going to let it happen.
Well, talk about bad evidence. So that part, those details may be off limits for trial as of now. But there are other details that appear to be fair game. Now, KGUN 9 reports that prosecutors can bring up earlier incidents where Scholtes allegedly left his kids in the car. And by the way, remember those text messages between Scholtes and his wife sent while paramedics were rushing Parker to the hospital? Those are being allowed in court too. That's a big win for prosecutors there, right, Kurt?
Oh, yeah, that is a big win. That's called prior bad act evidence, or prior act evidence is what we call it now, under a rule called 404B. And that's very difficult. And there's a very strict analysis that a court has to do to allow that type of evidence in, because again, that evidence is so prejudicial to a defendant. And it's really not about the facts of this case. But the court must have, I haven't read the ruling, but the court must have said, hey, this shows a pattern of previous conduct enough to show lack of care, enough that I think it's relevant enough to come in, even though it's going to be highly prejudicial to the defendant. So I think they kind of balance stuff out there.
How does he defend against that? Does he say, hey, listen, yeah, I was told this at other times, or, I think it establishes that, my panic in the moment, these are what these messages are about. How does the defense combat against that if it's coming in?
Yeah, that's going to be difficult. I think the defense is going to want to focus, hey, those are previous incidents, ladies and gentlemen of the jury. The prosecution's wanting you to look at that stuff because they don't want you to look at the evidence of what happened on that day. They're trying to distract you. They're trying to prejudice you against my client. I want you to forget about that stuff because it doesn't matter to what happened on the day that his child tragically died in the car. Let's look at the facts of today. But I mean, it's going to be tough. I mean, people are people, right? When you hear as a juror who doesn't sit through stuff like this every day, my gosh, he's done this before and he did it again. That's going to be tough to overcome.
Yeah, and so that ruling from the judge letting jurors hear about these alleged previous times that Scholtes left his kids in the car, that is significant because investigators had apparently already documented those claims. The day after Parker died, investigators, detectives apparently interviewed his two older sisters. And per an incident report from July 26, 2024, one of them told investigators, quote, her dad has accidentally left Parker in the car and that her mom had tried to do CPR, but she didn't know that she was already dead. And now the little girl said that her parents told her to tell police this was an accident. And the same interview shows how often this allegedly happened. According to the report, The girl also said her dad had left her and her siblings in the car 59 times and said he had also left her in the car sleeping when she was a little baby. And maybe the most shocking is when she said this, quote, usually her mom will get mad at her dad when he does something he's not supposed to do, like drink too much beer. He still drinks too much beer. And he keeps leaving us in the car when my mom told him, stop doing that. That's how he made my baby sister die. Now, Kurt, bunch of questions here. Are these children going to testify? And is this kind of evidence going to be allowed in?
In Arizona, a child can testify if a court finds that they're competent. If they know the difference between right and wrong, the difference between the truth and a lie, they can testify. So certainly the prosecution has that option. Certainly that's going to be a difficult decision to make for the prosecution because you don't want a child to testify necessarily. And you certainly don't want a sibling to testify in a case like this if that's at all possible. But I'm certain the prosecution is going to want that evidence in and want those statements in. If they can't find another way to get those statements in through maybe the interviewer, because we have hearsay rules that don't let certain statements in unless the person that made them testifies to it. If the prosecution cannot figure out another way to get those statements in, which are very damning to the defendant, the child very well may be a witness on the witness stand. I had a child witness when I was a prosecutor a long time ago, one of the most horrible experiences ever. So I'm sure the prosecution is going to do their best not to have that person testify.
Yeah. Now, something else I wanted your perspective on is that back in March, it was reported prosecutors had offered him a plea deal. So he would have pled guilty to a reduced charge to second-degree murder. If he had taken it, he would have faced 10 to 25 years in prison. Okay, long time. But now, with first degree on the table, he could be facing life. Apparently turned it down. Take a listen.
Mr. Scholtes, are you comfortable reading and writing in English?
Yes.
All right, you've been able to understand the court proceedings?
Yes.
And have you had any drugs, alcohol, or medication in the past 24 hours?
No.
Do you feel like you're thinking clearly today?
Yes.
And you've had the opportunity to consult with your attorney concerning the plea agreement?
Yes.
If you had questions about the plea agreement, were they answered to your satisfaction?
Yes.
Do you understand that the state does not have to offer you this plea again after today?
Yes.
The exposure that the attorneys agree on is that if you are convicted at trial, you would face a possible natural life sentence on count 1, and for the count 2, dangerous crimes against children, the sentencing range would be between 10 and 24 years. The presumptive sentence is 17 years. Both of those would be flat time sentences. Do you have any questions about that exposure at trial, if you did go to trial and if you were convicted?
Yes.
Okay, the plea offer that has been extended to you is a second-degree murder, which would be an amended count 1. The sentencing range exposure is 10 to 25 years. What is the presumptive, Mr. Travis? I'm sorry. 16. The presumptive is 16 years. That would also be a flat time sentence. Do you understand that that is a plea offer? Okay, and that there's a maximum statutory fine of $150,000. There can be up to 83% surcharge as well. There is also a requirement that the court order community supervision upon a completion of a prison sentence. Are there any other operative terms that the court's overlooked?
No, Your Honor.
Mr. Adair?
I don't believe so, Your Honor.
Okay. Mr. Scholtes, are you being threatened in any way to reject the plea agreement? Has anybody promised you anything outside of this courtroom or the plea agreement to compel you or help force you to reject the plea agreement? If this is your decision? Okay. And understanding the consequences and risks of going to trial, do you want to reject the state's plea offer to second-degree murder? Right, the court does find that Mr. Scholtes is knowingly, voluntarily, and intelligently rejecting the plea agreement.
Kurt, how common is that for defendants to reject a plea like that in a case this serious where there might be really, really bad evidence and limited defense? Does this make sense to you? Is it common?
Well, I mean, every defendant's a little bit different. This is somebody that I don't believe really has any significant criminal history. So they're not professional criminals, so to speak. And he probably heard 10 to 25 years, and that's likely flat time in this situation, meaning day for day. You're not going to do 85%. If you get 10 years, you're going to do 10 years. And probably said something along the lines, because I've had clients say this, I mean, what's the difference between 15 years and life? Which is kind of their mindset sometimes. Well, the difference between 15 years and life depends how long you live, right? So it's not uncommon to see something like this. Maybe the defense thinks that they can beat the first-degree murder, that this was such a tragic accident that no jury's going to convict him of first-degree murder when they know the serious ramifications of that. So they're banking on that. But man, it is risky. It is risky. Get out in 10 to 15, 20 years, or spend the rest of your life in prison when the evidence seems to be piling up against them.
Yeah, right now he remains behind bars awaiting trial. Jury selection set to begin later this month. If he's convicted, could face life in prison. Do you think this will come down to him taking the stand and explaining what happened?
I think he has to testify. I had to think about that for a minute. But, most of the time as a defense lawyer, you never want your client to testify. It's not helpful, generally very bad to do. But in a case like this, I think the jury's going to want to hear from him. I think the defense is going to believe the jury has to hear from him, explain what his conduct was, maybe explain about those other incidents, explain how he learned and why this one's different and why it's not first-degree murder. I think the defense is going to want him to try to build some sort of rapport with that jury so they don't convict him of first-degree murder. I don't see him getting acquitted across the line on all charges in this. I just don't see a jury doing that. But I can see a jury going, man, this wasn't murder. This was the dumbest thing I've ever seen, but not murder. So we'll see. I think he's going to testify.
Kurt Altman, thanks for taking the time. Appreciate it.
Thank you, Jesse.
And that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. You can follow me on X or Instagram. I'm Jesse Weber. I'll see you next time.